We are recording. Harvey Silverglate, Stephen Bonnell, thank you so much for joining me today.
Thanks for having me. Us.
And Stephen Bonnell. So Harvey, wanted to introduce you to Stephen Bonnell. He goes by the name Destiny. He's got to be like the most popular streamer out there. So he rose to fame with his video game streaming, and now he's a very well known political commentator. He appears on Piers Morgan and other outlets. It's kind of a weak introduction, Stephen, so I'm going to let you build it up a bit. But also, for those who don't know, Harvey Silverglate is John Eastman's lawyer, right? John Eastman is Donald Trump's lawyer. And Harvey, you're the co-founder of FIRE, so Foundation for Individual Rights and Expression.
Mm-hmm.
Did I get that right?
Correct.
Okay. Destiny, that was... Can you help me beef up your intro? Is that...
No, we're good. I just do online. I just scream at people online. That's all I do. Yeah.
All right, cool. So, Harvey, Destiny and I are hoping to talk to you today about a handful of things. If anything's off limits, just let us know. We'll move on to the next topic. But actually, let me pass the mic to you, Destiny. Why don't you ask a question?
Yeah, sure. How's it going, Harvey? You can hear everything loud and clear?
I can hear you loud and clear.
Cool. All right. So one of the things that I've been involved with lately is doing a lot of research around, obviously, the two political candidates, Kamala and Trump, and the upcoming election, and stuff relating to all of the events that happened during January 6th, and kind of like all of the stuff leading up to that. I guess I'm not sure how much you can touch on things. For instance, when you say that you're one of Eastman's lawyers, is he like retaining you for counsel over the stuff that he's dealing with right now? Or how much are you able to talk about in regards to like the ECA, the 12th Amendment, and the whole legal theory leading up to that? Yeah, you can tell me what you're comfortable with.
Well, Eastman has two lawyers, Charles Burnham, who's in Washington, D.C., and me. I'm of counsel to a Boston firm, but I do most of my work out of where I am now, my home office in Cambridge. The whole top floor of the house is devoted to my work. I have two research assistants here, and so I mostly work at home.
Okay. I guess, yeah.
I am co-counsel for Eastman. And I believe I was brought into the case because of my criminal law experience and my First Amendment experience. I am considered to be an expert in both criminal defense, academic freedom, and First Amendment. And the Eastman case involves all of those things, especially First Amendment.
What do you think are the First Amendment implications in the Eastman case?
Well, I think that the problem with the prosecutions are that they have not been thought through. A vast number of people have been indicted on a vast number of charges, some of which are clearly inappropriate. For example, Eastman, in my view, and I'm an expert on this, I taught legal ethics at Harvard, the Harvard Law School in 1994. This is one of my fields. Eastman's advice to Trump and to the rest of the group in Georgia and elsewhere was perfectly lawful. It was cutting edge. That is, it was not the typical advice lawyers would give, but he wasn't retained in order to give typical advice. He was retained in an extraordinary situation to give advice in an extraordinary situation. And he is going to trial. We have let the prosecutors know that there will be zero plea bargaining. He's going to trial on every case in which he's been indicted.
So typically when a client and an attorney discuss things, usually there is a privilege for the attorney-client privilege that you're not allowed to pierce except for with limited exceptions, one being the crime fraud exception. Now, I understand we can call Eastman's advice cutting edge, but when Eastman is giving advice on how to break a law, haven't we done a problem there? Isn't that a no good from an attorney perspective?
You're making a huge assumption that his advice to Trump was on how to break a law, and it was not. And that's where you have made the fatal error, and where the Department of Justice and the Georgia DA have made fatal errors. They're going to lose this case. They're not going to lose it against all the defendants. But trust me, bring me back when the case is over, and I can do it, and I told you so.
Is the Electoral Count Act, is that not a law for you, or do you think that that's...
It's not, the question isn't whether it's a law. The question is whether Eastman's advice was sound legal advice, and it was. There was nothing illegal about it. He was not urging the breaking of any law. He was acting as Trump's personal counsel, and that's going to be the defense.
If Eastman was having conversations with Pence and Trump and Mark Short and Greg Jacobs and encouraging them to contravene the ECA because of some different interpretation of, say, the 12th Amendment, would that count as him giving advice or counsel on how to break a law?
No, it would be he was counseling on how to deal with the law, not how to break it, but how to follow it in a cutting edge fashion.
Well, I mean, breaking the ECA, it wasn't following it. It was saying the ECA would be ruled unconstitutional, hopefully by a future Supreme Court, right? The idea was that law had to be tossed. No?
Yeah, you're allowed to do that. That's not the same as, burglary or homicide. You're allowed to do that.
You're allowed to have a unique constitutional interpretation in order to break a law. Well, but then couldn't you just break any law if you wanted to and say, well, I think that the First Amendment would allow this, or I think that the 12th Amendment would allow this, or?
Nope. The answer is no to that question.
How do you determine which laws are okay to break and which ones aren't based on a personal interpretation?
Sound legal analysis. Remember, he was an academic. He taught the law. Sound legal analysis. Each case has to stand on its own facts and its own law.
Okay.
See, the problem in this whole mess is that the thinking of prosecutors is exactly the same as your thinking. There is absolutely no respect given to nuance, to detail, to footnotes. These are all bulls in china shops.
Well, I mean, the issue is that the ECA had been followed for some 140 years, right? And we didn't seem to have any problems with it. And for somebody to come out with a novel constitutional interpretation that would just so happen to basically kick the entire ECA to the curb, and then Eastman would later even admit in personal conversations that the Supreme Court probably wouldn't defend it.
That's what they said about Brown versus Board of Education, and the Supreme Court decided otherwise. And I could tell you that I could probably name at least half a dozen cases. The school desegregation case is one. The Pledge of Allegiance to the flag is another. There are a large number, but maybe not large, but I could easily name 6 cases where the Supreme Court broke new ground because creative arguments were made by the ACLU, by FIRE, by my organization, and suddenly the law got clarified. Some would say got changed, but we expect to win ultimately, if not in the trial courts, in the appellate courts.
So for something like, if we think of something like Brown v. Board of Education, and we think of like equal protections, if we look at the ECA and we look at the 12th Amendment, on what grounds would we imagine the Supreme Court would end up tossing the ECA? That Eastman's interpretation of the 12th Amendment was just true, and he was the first legal scholar in over 100 years to figure this out? Or
it doesn't have to be accurate. It just has to be offered in good faith. The Supreme Court could, in the end, disagree with Eastman's interpretation, but that is not the question. Because if a lawyer, in good faith, mind you, gives advice, the advice is under a creative interpretation, possible, but at the end it loses. In a criminal setting, the giving of that advice is not a crime.
Sure, but I mean, I imagine we'd have to be able to figure out whether or not it's creative interpretation done in good faith versus bad faith, just for accomplishing somebody's personal ends or something, right?
Well, That's going to be for the trial judge to instruct the jury and for a jury to decide, and then for an appellate court to review the jury's decision based upon the propriety of the judge's instructions. We will go to trial. We expect to win. If not at the trial level, then on appeal.
Do you think that if Jacob's testimony is true, and if Eastman admitted to him on first glance that they'd probably lose in the Supreme Court 7-2, and then they'd probably lose 9-0, does that speak to how good faith or bad faith the legal counsel might have been?
I don't understand your question.
So let's say somebody says we're going to challenge this law because we think that the 12th Amendment supersedes this law. This law is unconstitutional. And then, upon further investigation, when you're talking to this person, like, yeah, if we went to the Supreme Court with this, we'd probably lose 9-0. Does that speak at all to whether or not the legal advice is being given in good faith or bad faith?
Well, are you looking at this prospectively or retroactively?
This would have been prospectively before January 6th when Eastman was talking to Jacobs. I think Eastman said, or Jacobs testifies that Eastman said that if they were to go to the Supreme Court with this, they would lose 9-0 basically. And this was before January 6th, so this would have been prospectively.
The question is whether they will lose in the Supreme Court or not. I do not.
Yeah, but if you think you're going to lose 9-0, it seems like you're probably not giving advice in good faith. No, right?
No, I disagree with you. You could think you're going to lose, but you could offer cutting edge advice in good faith and not have committed a crime. You don't have to be right on an issue. You only have to give your advice in good faith and a good faith belief. I've had many cases where a client has said, well, I'd like to go to trial. What are our chances? I said, our chances are very low, but, it's up to a jury. It's up to a judge. It's up to an appellate court. And in some of those cases, we've lost. In some of those cases, we've won.
Sure, but I mean, there's a difference between saying, like, can you beat a jury or not, or can you win a jury trial or not, versus do we think that this person has, committed a crime, or do we think that this person is acting in good faith or bad faith, right? There are times where somebody's obviously committed a crime and almost for sure done it, but we wouldn't win in front of a jury, or we couldn't get a conviction or something. It doesn't necessarily speak to whether we think the person was acting in good faith or not, right?
Well, I don't know. You keep asking me the same question. You're getting the same answer.
Sure. Okay. I guess my interpretation, looking at all of it, is it looks like Trump was very clearly trying to solicit opinions that would further entrench his power in the White House. And to do that, he stepped outside of all the official White House counsel, and he went to people like Giuliani or Sidney Powell or Chesbrough or Eastman in order to solicit whatever outrageous legal theories he could in order to try to maintain power. And Eastman was the one through Chesbrough that hooked him up with this crazy idea of just tossing the ECA and saying that the vice president himself could basically choose the winner of the election. And I don't see any reading of the 12th Amendment or the Electoral Count Act or the roles of any of the parties involved that would allow that in good faith to happen. Like you must have to have a totally different interpretation of the structure of government.
Fortunately, you're not on the Supreme Court. I'm glad of that.
Yeah, I am not on the Supreme Court. Although, again, your client says that he would probably lose at the Supreme Court 9-0, so I don't know how that's relevant. But
I have given many clients advice, which I told them in advance, we probably would lose, where in fact we've won. It is not criminal to give advice where you think you're going to lose, but it's offering the good faith possibility that you could win.
Yeah, but if you're giving advice on how to break a law, the ECA is a law, and he was giving advice to break that law.
You're being very tautological here. You're not giving advice on breaking the law. You're giving advice that you think might or might not be upheld by an appellate court. That's not the same as saying to somebody, pull this trigger and kill this person. Go rob a bank.
It might not be the same as breaking one of those laws, but the way that you just said in an appellate court, he's not talking about how the law in and of itself could be interpreted differently. He's talking about going up to the Constitution and doing a different type of interpretation of the Constitution to say the entire law should be struck down, which I think is, using that argument, I think you could argue basically anything. This is unconstitutional, so I'm going to give advice to a client on how to break, how many laws. Like, I think you should actually be able to do conspiracy crimes because that's a violation of your First Amendment right. You're just talking. Why should this ever be considered a crime? And then giving advice on how to carry those crimes out. I think that would be not good. I think we would all agree we would want attorneys to be able to give advice like that, right?
You keep making the same mistake. You're abusing the English language as well as logic. You're not giving someone advice on how to break the law. You're giving somebody advice on interpretations of the law that are unlikely but possible.
Okay. I mean, I think we know where we stand. We can circle the drain on this. Did you want to, Jake? Did you have any?
So Harvey, where do you think that destiny is missing you on this? You're saying that, I think what you said is destiny is not understanding the logic of this, or he's using the English language in a way that where he's making a point that you think is fallacious. So
he doesn't understand the role of lawyers. That's the problem.
And what do you mean by that?
I understand the role of journalists. I used to be a journalist. You don't understand the role of the lawyer.
And what specifically? Just so we can move on. But I just want to try to find the specific point of disagreement. You know, what is kind of underneath this? What's the foundation of where there's this disagreement? So what specifically is Destiny not understanding?
He's not understanding that it is not easy to understand and interpret all these statutes, especially in a situation which is unprecedented. And that if a lawyer comes up with an interpretation which the lawyer thinks is probably wrong, but which the lawyer thinks could possibly be upheld. You know, the current Supreme Court, with its conservative majority, has overturned precedents that were half a century old. Nobody would have predicted it, but it happened. Affirmative action just got overturned the last term. It's shocked all the universities.
So
it happened.
Just to be clear, when we're talking about Dobbs and we're talking about Chevron being overturned, this is the Supreme Court. The Supreme Court is in the purview of the
about Chevron, by the way.
Well, I know, but you're talking about these are overturning things. These weren't laws, right? These were other prior Supreme Court decisions.
We're talking about overturning the affirmative action, college affirmative action case. That's the one I referred to.
Oh, I heard Roe v. Wade. Sorry.
Destiny, does Harvey's critique make sense to you? Do you agree or disagree with what he said? In other words, I think what he's saying is there's the nuance to the law that maybe he thinks you're losing in your analysis, that you're not accounting for the specifics on how the laws work and can be interpreted. Is that fair?
Oh, no, I understand what he's saying. I think that as a general piece of advice, I think what he's saying is absolutely correct. That there are a ton of different laws on the book. Some of these can be contradictory. Some of these can be untested for long periods of time. And when you go to an attorney and you're trying to navigate, especially like a novel environment, you might be asking like, can I do this? Is this against the law? And it's like, well, this is untested. Like we could try this. Like, I think that an attorney is squarely within their rights when they're operating in good faith to give advice like that. I think as a general rule of thumb, for sure, that's true. And then even more precisely, there can be important challenges to things where you think, well, I think you have a First Amendment right to do the sign or, whatever, where these cases work their way up through the courts because you have people that are willing to represent defendants that are trying to test certain things. I think as a general rule of thumb, everything he's saying is correct. I just don't think any of it applies to the Eastman case. It's very obvious that Eastman's not offering advice in good faith. He thought he would lose to the Supreme Court. We're not talking about like a smorgasbord of complicated federal statute or regulation. We're talking about a very clear Electoral Count Act that's been followed pretty much to the letter for 150 years. And the advice that Eastman is giving is not some like cutting edge novel theory on how you could maybe, work within the bounds of this law. He's saying that you would have to violate the ECA at multiple steps, and we would have to appeal to the 12th Amendment as being the thing that would save us, which is another common logical fallacy where people put constitutional amendments or constitutional law on the same level as congressional statutes when they're not. And the idea that somebody could just come in and go, oh, actually, I think this is unconstitutional, which this determination would only happen in the Supreme Court. And Eastman himself says that this would lose in the Supreme Court, first 7-2. And he's like, I would actually probably lose 9-0. Shows me in my mind that the advice is not being given in good faith. He's giving advice to his client on how to break a law, assuming that the Supreme Court won't even hold it up.
You're describing the school desegregation cases.
The segregation cases?
Yeah, school desegregation cases.
How? In which way?
Well, who would have thought that Thurgood Marshall was going to win those, arguing them in the Supreme Court? But he did. It was unprecedented.
Weren't those argued under equal protections?
Yes, so
So there's a legal argument that you could see there, right? That case, I think it was only 14 pages long. The argumentation for that case is constitutionally and legally sound. That the equal protections guarantees that if a state should
it's
pass some
legally
law or
sound
provide something, you have to.
only because a majority of the Supreme Court suddenly did the unpredictable and said it was legally sound. It was not legally sound until then.
Do you think there's no way to see if a reading of a statute in how it would comply with the Constitution? You don't think there's any way to know if that's sound or unsound before 9 judges say if it is or isn't?
Absolutely.
Okay. So I think that we can probably say there are some challenges that are done in good faith, and there are probably some challenges that are done in bad faith. But with the way that you've laid out Eastman's case, it sounds like there's no way in your world there could ever be a bad faith challenge. Because you're saying, well, the Supreme Court's done crazy things in the past. Maybe they will say that all forms of conspiracy to commit crime are all illegal.
Absolutely not true. If you have somebody now who is running a lunch counter who refuses to serve a person on the basis of race, religion, national origin, that's pretty clear. There are some things that are clear. If you have somebody who goes into a bank with a gun to make a withdrawal, that's pretty clear. There are issues that are so obvious that even an idiot can understand them.
Yeah, this is not one of those cases, though, right? The ECA, in terms of, I don't see how you could ever do a reading of the ECA of the 12th Amendment where it's so obvious that the vice president should be able to just toss the entire ECA. And I don't see how you can ever say that the advice is being given in good faith when he says he would plan on losing in front of the Supreme Court. And the advice you're given is to break a law.
No. The advice was given. Let the courts decide. It was obvious it was going to be litigated. Let the courts decide. It's not you're not doing exercising power out of the barrel of a gun.
Well, but you are. If you can't say let's break the law to circumvent the election, and then we'll let the courts decide at a later date.
You're talking in tautologies here. He didn't give advice to break the law. He gave advice on how to get around a certain result by interpreting the law in a creative way.
It was a rejection wholly of the Electoral Count Act. The reliance was on the ECA being ruled unconstitutional. So it's breaking that law. It's hoping that law won't count.
That's correct.
So how is that not breaking the law?
It's not breaking the law. It's allowing the courts to test the law.
But in that case, then an attorney could never give you advice that's bad then, because you could always say, I just want the courts to test it, no?
Let's get on to something else, because we're just going around in circles here.
Okay.
And just to put a pin in this, so I think the point of contention is Destiny is saying, well, how do we know if you can stand behind any law being potentially broken, then it's impossible for anything to ever be in bad faith because everything is defensible. Destiny, is that kind of to summarize your point? I think what you're saying
basically,
is that okay? And then Harvey, what you're saying, we'll move on. I think what you're saying is Destiny is wrong because it's not the case that anything is defensible. There are certain things that are indefensible that you can't defend in good faith, and this is not one of them.
That's correct.
Because the nuances of this case meet the threshold, which you would say is there's enough ambiguity. There's enough ambiguity, Harvey, you're saying, that it's reasonable for someone to be doing this in good faith, and it's not fair to say that they are necessarily in bad faith. Is that accurate?
Correct. And thankfully, in our system, it's up to a jury to decide that, not up to the trial judge and not up to journalists or commentators or anybody else.
And so, Harvey, if I were to try to make this, quantify this a bit, for the sake of this conversation or for Destiny or myself, is there a way to describe what that threshold is where you would say, okay, that person's clearly breaking that law, trying to defend that is got to be bad faith? Or maybe there is no threshold. Maybe it's for interpretation. I mean, would you say where would we draw the line?
Well, we don't draw the line. Ultimately, the courts draw the line, and ultimately,
Yeah.
it's the Supreme Court that draws the line.
So, Destiny, why don't you think what Harvey's saying
Hold
is
on, I have to wait. I'm so sorry. I have to say, just real quick, for any aspiring lawyers out there, the idea that you would just operate as a criminal co-conspirator and hope that the courts figure it out is probably not the advice you would give any attorney, right?
I don't think
Like,
that's what
well,
he's saying.
But
That's
there
not what he's saying.
again, this is a tautology. You keep saying operating as a criminal. Not everybody would agree. I don't agree that he was operating as a criminal. I have been a lawyer for 60 years. I did very well in law school.
that's fine, but I don't think you would tell an attorney to just say like, "Oh, well, give him this advice, and we'll let a court figure out if you're
That's not
about
what
to
he's
get
saying.
disbarred or
That's not
not."
what I'm saying. You
Yeah,
keep
Harvey, clarify
putting
what you're.
words in my mouth. This
Yeah,
is
that.
insane.
So, Harvey, I think so just for the sake of clarity, could you restate your point that because so I think Destiny, yeah,
A lawyer in a difficult legal situation is entitled to give cutting edge advice that 98% of his fellow lawyers might think is wrong, but which has a sufficient chance of persuading appellate courts that it's offered in good faith. It's not offered it's not being implemented out of the barrel of a gun. It was obvious it was eventually going to get into the courts. And it's perfectly lawful to give such advice. And you can't go around indicting lawyers for giving cutting edge advice. It's very bad for the legal system.
And Destiny, you would agree that there are cases where lawyers can defend a client for something that might be illegal, but it might not be illegal, right? And they can do so in good faith. And I think what you're saying is that in your opinion, in this specific case, you don't think there's any chance that there was anything legal going on. And so Destiny, you think it's done in bad faith, right? But
my understanding, and I'm not a lawyer, I've never been to law school, but my understanding is one of the few exceptions where you can pierce attorney-client privilege is the crime fraud exception, which is when you are getting advice from a lawyer or an attorney for making plans to break the law, basically. And if you're enabling a client to break the law, not defending somebody who has broken the law, but you're like planning with them, that's one of the few times that you could be held one that veil can be pierced, and then you could be held criminally liable for it. I think that's why
Destiny is engaging in what we call a tautology.
yeah, I want to ask you about that. I was about to ask you, what do you mean by tautology? You've mentioned it a few times. Can you describe that?
Yeah, you say where a lawyer is advising a client on how to break the law. That is not what that's a conclusion. What he was doing was advising on an interpretation of the law that will allow the client to do what the client wanted to do.
Wait, you keep saying that, but that's not true. He wanted to break the ECA. He didn't want to reinterpret it. He wanted to break the ECA, which is a law from Congress. It's breaking the law. There's a plan to break that law.
How is he trying to break the law rather than get around it? Is there no difference in your view?
Well, yeah, the ECA is what set forth the procedures to be taken place on January 6th, and it dictated what the vice president should do. And Eastman's memos, both of them, gave advice on how to break from the ECA procedures.
Now, wasn't it obvious that was going to end up in the court, sort of like Bush versus Gore? Wasn't it?
I don't even know if that is going to end up in the courts. Is it? Is that even?
Why would it not end up in the Supreme Court? Why would that not be reasonable in Eastman's mind?
Because it's not reasonable. It's ridiculous. And that's why Eastman himself said it would lose 9-0. There's no sane human being that would have this interpretation. You're clearly just soliciting the help of an attorney for a crime. What?
Harper, what'd you say?
The current Supreme Court has made some decisions that, shocked the New York Times, for example. But all the precedent, isn't it obvious? Well, it wasn't obvious to 5 members of the Supreme Court. You just don't understand the role of courts of ultimate jurisdiction. They can say whether or not something is ridiculous or not ridiculous. It's not up to us.
Harvey, you mentioned something interesting, that there's a difference between trying to get around a law versus breaking it. Can you help me understand that difference?
Yes. Getting around it is figuring out an interpretation that would allow you to do what you want to do.
Yeah.
And done very openly, so that if somebody wants to engage in appellate review, they can go to the courts. This was not a secret conspiracy. The whole world knew about what was going on.
Destiny, do you agree with that? Do you see what his distinction he's making between getting around a law versus breaking it? Trying to what do you disagree with there?
No, he's breaking a law. I think this is a strange trick sometimes that people play when they try to put the Constitution on the same level as congressional statute, and it's not. They were saying they wanted to break it wasn't favoring one interpretation like the 12th Amendment over the ECA. The Constitution does not sit on the same level as congressional law, and the idea that Eastman himself could give this determination that, like, oh, well, obviously, he's going to say I'm committing a tautology again, but in his world, there's no way to break any law ever as an attorney. You can never. There's no such thing as the crime fraud exception, I guess, because every attorney can say, "Well, I'm just giving novel legal advice." Like, there's no way to do it.
So let's talk about this. When is someone breaking
a
law?
Here's a very specific example. I go to an attorney and I say, I really want to. There's a lady down at the store and she always gives me this evil eye. Okay, and I want to kill her. Okay, so give me advice on how to do it. And the attorney goes, well, personally, I think it's my First Amendment right to give you that advice, and I don't think that there'd be any sort of a conspiracy to commit crime thing that would happen here. There is no conspiracy.
You got the wrong amendment, by the way. It's the Legal Advice of Counsel Amendment.
Sure, but I'm saying, what if this attorney thought that he could help his client plan a crime to murder somebody because he thought that was his First Amendment right to do it?
If
so whatever
you are equating advising a client to commit a murder with advising a client on how to get around the statute concerning elections, you're so often left field. I can't deal with it.
Both of them are advice on how to break a law. No,
you're
getting around the law.
Conclusory terms. Break.
Yeah.
Those were Eastman's own words. Departure from the ECA, breaking the norms of the ECA. They're breaking the ECA. That was Eastman's own words.
Well, Harvey would say he's getting around it, not breaking it, right, Harvey?
No, he's not getting around it. He's breaking it.
Okay,
that's correct.
Okay, well then you're just getting around the laws on conspiracy to commit murders.
Well, Destiny, is there a difference? And I'm not a lawyer either. Is there a difference between a law where you say, this law is this law is either bogus or it could be, it's not perfect. Let me see if there is a way to work around that law. Is there room in the U.S. legal system to, as Harvey said, get around a law? And is that different from breaking a law? Destiny, what do you think?
Yeah, there's going to be differences. When somebody says get around, now again, remember, I'm not a lawyer, I haven't been to law school, but in my mind, when somebody says get around a law, what I'm thinking of is they found a way where the law doesn't apply in a particular way.
Yeah.
They think that it doesn't apply for some reason, right. Or you don't fall under, whatever's declared, it affects these people or whatever. But for the Eastman advice, they knew that it applied here. Obviously, it was the process.
What do you mean they knew that it applied, but they're saying they don't think it applies?
No. That's yes. Harvey keeps saying that, but that's not true. He knows it applies. That's why when Eastman, every time in this this gaggle of lawyers, not including Harvey, but like the Eastmans, the Giuliani's, just when they say constitutional, that's code word for breaking the law. Because what they're saying is we think that these laws are BS and we want to get rid of them, so we're going to follow the Constitution instead. That's what they're saying. They're not trying to get around the law. If they were trying to get around the law, they would never have to appeal to the 12th Amendment. They would just say, oh, well, this law doesn't apply here. But that's not what they say.
How would they say it doesn't apply?
The major tests of constitutional principles have been brought. The only tests have been brought by people who broke the law. Unless you break the law, it doesn't.
With advice of a lawyer?
It doesn't get into court as a test case. In the school desegregation cases, which I use as the prime example, those kids black kids who went into the white schools broke the law. They intended to test the law, and the only way to test the law is to break it.
We're not talking about clients. We're talking about attorneys. There's a difference. You would agree. There's a difference between an attorney finding a client that he wants to defend his broken.
Were advised by attorneys.
And so, if an attorney is advising you to,
do you think 7-year-old kids made the decision to try to get into white schools? They were advised by lawyers.
Well, generally, your parents are the ones sending you to school. And I think there probably were a lot of parents that were telling their kids that they wanted to go to school regardless. But there's a difference between somebody breaking the law and somebody defending you versus you breaking the law on the advice of an attorney.
Can I make a suggestion? We've been going through this merry-go-round now for an hour.
Yeah, and they'll move on.
Okay,
we're never going to agree.
Well, the crux of the disagreement, and either of you should correct me if I'm wrong. The crux of the disagreement is that Harvey is saying it's not necessarily breaking a law if you're trying to find a way through the law, around the law. Like, the laws have flexibility. And Destiny, I think what you're saying is, like, Destiny, would you not attribute any flexibility to the way that we can deal with laws?
Yeah, you can. The distinction that we're that is not being made right now. I don't, for some reason, is there's a difference between a client breaking a law and a client breaking a law by the advice of the attorney telling them.
No, but the whole breaking the law. Okay, Harvey wants me to move on, so I'm going to.
There's no difference between those two things, Harvey. There's no.